Hello ladies and gentlemen, welcome back to my channel. In this video I'm going to talk about consideration. I received so many requests from the students to talk about consideration in a simple way. So this video is a short video principally talking about consideration, the rules governing consideration, what is consideration, how does consideration fit in with the other principles of law of offer and acceptance. So what is consideration? Look at consideration as though it is what you forego. Either it can be a benefit, a loss, a detriment, anything that you forego, that you've lost or that you've incurred or that you've spent. That is consideration. So let's assume we agree that I sell to you my Benz, okay, and you're giving me 5,000 shillings. The consideration you give me is the 5,000 shillings. The consideration I give you is the Benz. So both of us furnish consideration. Consideration comes from you, who's giving me the money, and consideration comes from me, who's giving the Benz. So that item that you forego, or that you endure, or that you go through, it could be monetary, it doesn't have to be monetary, all that is deemed to be consideration. So that's why we say that consideration is a right or an interest or a profit or a detriment or a benefit that one party goes through, or a forbearance or responsibility that is suffered by another person. So it's really the cost, and that cost doesn't have to be monetary. It is something you forego. Whoever that your side of the bargain, what you forego, what you take in, what you put in, that is the consideration. Now I want to talk about the relationship between offer, acceptance, and consideration. I want you to understand that for you to have a valid contract, you must have an offer that is valid, and you must have acceptance that is valid. And you should have the capacity to make the contract. So once you have an offer and an acceptance, you automatically have a valid contract. But for you to be able to enforce that contract in law, you must have furnished consideration. So consideration is what gives you the right to enforce a contract. Consideration relates to offer and acceptance, in that offer and acceptance give you a valid contract, but if you did not participate in furnishing consideration, then you cannot enforce the contract. So for you to have the right to enforce the contract, you should have furnished consideration. This is the same principle you see in the doctrine of privity, that you must have furnished consideration for you to be party to enforce a contract. So now let's move on to the different rules on consideration. And the first rule I want to talk about is that consideration must move from the promisee to the promisor. Really what this is saying, that consideration must move from one party to the other. In other words, the person to whom the promise is made is a person that must have furnished consideration. So you'll find that if I have promised to give you a Benz, or to sell the Benz to you, for you to enforce my promise, you must have consideration coming from you to me. So you're the promisee. In essence, we are saying that either party to the deal must have consideration move from them if they are to enforce a contract. So you'll find in this case, Tweedo versus Atkinson. Tweedo and William Guy entered into a written contract to give money to a third party called William Tweedo. So two guys decide they are going to give money to a third party. So one of the guys, William Guy, doesn't pay the money as promised, and then he dies. After his death, the third party who they had promised money, who was not party to the written deal, seeks to enforce that promise by looking at the estate of Guy. But he did not succeed because the law says that he was not a party to the contract. The contract was between the two original people, Tweedo and William Guy. For him, he was only a third party. He could not enforce the contract because he did not give consideration to secure that promise of the written promise. So the court said that consideration must move from the party entitled to sue upon the contract. So here we are really saying that consideration must move from the promisee to the promisor. So the second rule is that consideration must not be past. Past consideration is not good consideration. And what do we mean by past consideration? This is a scenario whereby the promise is made earlier than the agreement. For example, where I decide that for the things you did for me 2 years ago, I'm going to pay you. So you already did the things 2 years ago, and I'm making the promise now that I'll pay you. That is past consideration. Consideration given before the promise is made. So if you look at the general rule, it says past consideration is not sufficient consideration. That is, if the consideration given is past, you cannot enforce it because the promise came way after the consideration was given. If you read this case of Remark Addo, the claimant had spent her own money to improve a house belonging to some relatives. So this lady spent her money to improve this house that belongs to the relatives. After she has done the renovations and everything, the relatives promise that they will give her back some payment of sorts. So the promise of payment or repayment comes way after she has finished everything. So that is a past consideration. So here we're saying that after the improvements had been carried out, the relatives signed a document promising to pay her back her money she had spent on the improvements. So the relatives failed to honor their promise and she sues them to enforce the promise. She did not succeed because she had done the improvements way before the relatives had made the promise. And court was not willing to treat her claim as valid consideration because the relatives' promise was not the same transaction as the improvements that she did. So really what we are saying is that past consideration is not good consideration. Where you do something way before and then someone promises you much after, that is not good consideration because you're not foregoing anything at the time the promise is made. There's nothing to allow you to or enable you to enforce that contract. So the rule on past consideration has an exception, and the exception is that if you requested the promisee to carry out the act that constitutes the past consideration. So let's read Lampley versus Brathwaite and you understand what we're talking about. So in this case, Brathwaite, he had killed a man. So he had already done his act, he had killed the guy. So he asks Lampley to help him meet the king and get a pardon and that he would pay him for his services. So the act of killing was already done, but he's now making the promise, if you close the deal for me, I'll pay you. So Lampley meets the king and obtains the pardon. Now after he has gotten the pardon, Brathwaite promises to pay Lampley £100, but he doesn't honor his promise. So Lampley sues to force him to honor his promise. Court held that Brathwaite's prior or original request contained an implied promise for him to pay a reasonable sum, and that sum was only closed way after of £100. So the actual £100 declaration was only sealing what he had already promised to pay. So court interpreted that the original promise to pay was the same transaction as the final time where he was just clearing the amount that was going to be paid. So court treated the prior request and the final promise as part of the same transaction. So in this case, what they're really saying that if you requested the guy and you promised him that you would pay him and you just didn't clarify, and much later you're trying to clarify the amount, for example, or the consideration that you want to be given, court will deem those to be the same transaction. It will not be a separate transaction that there was no consideration given or that was past consideration. Court will deem it to be the same transaction. So the question here really is, can it be interpreted that the transaction you're talking about can be deemed as one transaction? I hope that is clear. So the next rule is that consideration must be sufficient. It doesn't need to be adequate. And really this rule is saying that any kind of consideration will be deemed to be effective consideration. In other words, court is not going to look into the value. For example, if I'm giving you a phone and you're giving me 1 shillings for my phone, as long as you've given me something, the 1 shillings will be deemed to be sufficient. It doesn't need to be adequate. And here adequate, we are saying it doesn't have to be commensurate in value. It doesn't have to be of equal value. As long as you give something, that will be deemed to be sufficient consideration. If you look at this case of Thomas versus Thomas, the defendants promised to transfer a cottage or a house to the other Thomas. These are probably spouses, husband and wife. So one promises to transfer a house to the other Thomas, and in return the wife was going to pay £1 per year as rent. So you find that £1 is too little for you to pay as rent, but court does not look at the quality, the value you are touching. Court looks at the fact that have you put something, is it sufficient? I mean, have you put something? Once you put something, that is sufficient. So in this case, court held that the defendants were bound by their promise as the claimant had given sufficient consideration. In other words, the £1 was sufficient consideration. Court makes itself clear that court is not concerned about the adequacy or the value of the consideration or how weighty it is. It doesn't have to be of the same weight. As long as something has been given, that will be deemed to be sufficient. In other words, consideration just has to be sufficient. It doesn't have to be adequate. It doesn't have to be of equal value. It just has to be that you have given something in consideration. There are two main exceptions to this rule on consideration need not be adequate, and the first exception is that if it is in exercise of a public duty, you will be expected to perform more than what the public duty is. In other words, court will not say that consideration need not be adequate if all you're doing is your public duty, because that is really, if you do something that is not beyond your public duty, you've not given any consideration. So with respect to an existing public duty, the law requires that you perform more than what your public duty is if you're to say that you furnished consideration. In other words, court will look into adequacy or in the kind of consideration you're giving for as long as it is in relation to exercising a public duty. Let's read this case of Collins and Godfrey. Godfrey was a litigant in a case, like he was suing in a case, and he had caused Collins to be given an order to come as a witness. So he had asked Collins to come and be a witness in his case. And remember, when you're asked to be a witness, that's a public duty you're expected to do for free. So Godfrey promised Collins to pay him some money for the time he's going to spend in attending court, and then he fails to fulfill his promise. So Collins sues Godfrey to enforce his promise. But court held that Collins had not given any consideration to Godfrey to enforce the promise of payment, because court said that if it is a duty imposed by law on a party who has been called to attend from time to time to give evidence, then a promise to give him any payment for loss of time in such attendance is a promise that is done without consideration, because court was saying they think that such a duty is imposed by law. In other words, it was a duty imposed by law that someone who's called upon to give evidence as a witness should come and is expected to do it. So this guy was not doing anything outside his expected public duty. So there was no consideration deemed to be given, because he could not, because they were saying he didn't do anything beyond what is expected of a human being on their duty to the public. So in other words, this exception is saying that as long as you're performing a public duty, the court will inquire to see whether the kind of consideration you've given is valuable consideration. That is the exception. The second exception is whereby someone is bound by contract to do what they're supposed to do. For example, you have a contract with your spouse or with someone to pay school fees for you, okay? And that is their contractual duty. The law says that even if you say that, okay, if you do it for me, I'll give you money, the law says that that is not sufficient consideration, because they are already bound in contracts to do what they are doing. So whatever they are doing cannot be deemed to be consideration, because what they are doing is already expected of them to do. So court will say that that is not, they've not given any consideration, because they're only they're only performing their contractual duty in doing that. So consideration will be expected to be done beyond the contractual duty. The third exception is in case of part payment of debt, and I talked about part payment of debt in a separate video. Please feel free to look at it so that you understand how part payment of debt works. But part payment of debt as an exception to the rule of adequacy is that if you've given part of your money, I mean you've given only part payment back on a debt, the law says that that is not full consideration. You've not given, you can't force someone to accept only part payment and walk away saying that, okay, I've forgiven you the balance, because the law says that you've not paid the full, it doesn't cover the full. So these are really exceptions to the rule of adequacy, but the main principle you have to understand is that consideration need not be adequate. It just has to be sufficient, except they will look into consideration to see if it was sufficient while you're performing a public duty, where you're performing a contract that you're already under to perform, and in case of part payment of debt. Then the law will say that what you have given is not sufficient. You have to give more than what you're doing so that you can say that you have furnished valid consideration. I hope this video helps you understand the principles of consideration better. Look out for the video that I'm going to do on the doctrine of privity, so that you also understand privity as a principle, because it still falls under consideration. And in privity, we are saying that if you're not party to a contract, you have not given consideration, you cannot enforce that contract in law. Thank you for watching. Have a good day.